Good afternoon, everybody. We're enjoying the last bit of the sunny, warm, beautiful weather. It's a great day outside, and we thank David for joining us today and clarifying a few things about estate sales. A lot of questions keep coming up. We have a maturing population in our province. A lot of us will be coming across estate sales, and my whole point when I asked David to do this was that it's not just when you're faced with sales like this, but also to maybe possibly start thinking about your clients or your clients' parents that are in that position where they're aging and you want to make sure that they're safeguarded. Obviously, you're not giving any legal advice, but at least be aware of what you might be faced with. Um, and then on obviously ask the Kormans to help out with your issues and your clients' issues. So welcome on board, everybody, and of course, David Korman.
Well, thanks, Sabiha, and it's great as always to be with you, Sabiha, and David, and everybody else at Sutton Summit. Most of you, I see, mostly very familiar names on here, and everybody sort of knows our history. And anyways, I always, as most of you probably know, I do a fair bit of, webinars and seminars for brokerage and everything, but there's always a special place in my heart for doing one for your office with our connection, our history, and the great relationship that we've had for so many years, which is continuing. So thank you very much for having me for this one. I've got a presentation, a PowerPoint presentation that I'll run through because it'll just sort of keep me on target a little bit. But we're going to focus this on basically what Sabiha was asking for originally was, estate sales, how to use a real estate agent handle these things when you're going to be acting on behalf of an estate. So in order to get there, I want to lead you through some of the general terminology and procedures of what happens with when someone dies. And at the back end of this slide presentation, I have a bunch of information on what goes into a standard will and power of attorneys. So if we have time, we can certainly go through that. If not, you'll have that as a resource. And you should always keep in mind, like, some of this is for your clients and potential clients. But when we start talking about wills and power of attorneys, you got to think about it from your own personal point of view. Are you protected? Do you have a will? Do you have power of attorneys? Is your family protected? Or members of your family protected? So keep that in mind, because what applies to your clients will certainly apply to you as well. So this is just the usual picture to give some contact information, show you what I looked like pre-COVID. I've been reluctant to go to get an update of the picture, but any picture is going to be neck up. We're not going to do anything showing the waist or anything like that when we do get around to doing. Most of you are familiar with our areas of practice: real estate, corporate, commercial, wills, and estates. And some of you may not be fully aware of that, but we're primarily a real estate boutique law firm. So we do high volume residential transactions. We do a lot of commercial transactions. We do a lot of commercial, industrial, retail leasing work as well. And we do incorporation of businesses. And for many of you, we've done PRECs already. For those of you that haven't considered it, please think about it, ask the right questions, speak to Sabiha or David or me about that. If it's a good idea for you, it's not always a good idea for everybody, but something you should consider. Anyways, we do purchase and sell small businesses, things like that. But as part of that practice, we also will do some stuff on wills and estates. These issues come up. So we are not providing estate tax planning advice. We're not equipped to provide tax advice. We know what we know. We also know what we don't know. So if someone really needs some sophisticated tax advice or estate planning advice, we'll refer them out. But for most of the population that need basic wills, basic power of attorneys, things like that, we can certainly do that for you or your clients. So keep that in mind. And you know where we are: in Mississauga, our head office, our Toronto office, Bathurst and Lawrence, and our Markham office as well. Plus, I'm talking to you today from my Richmond Hill home office. And I always say, wherever there's a Starbucks or a Tim Hortons, we have an office as well. So please get in touch with us. Now, most of you hopefully have all been tuning in to our podcast, the David and David on Real Estate. We just recently recorded our 60th episode. Yesterday was our 61st episode. David and I are really proud of the progression we made on this. There's a fabulous library of information for you. You don't have to tune into every one. You don't have to listen to every minute of every podcast. Take a look at the table of contents. There's some really good information in there on different topics, including today's topic. If you have any ideas, please get in touch with David, get in touch with me or Sabiha with suggestions for future podcasts, for guests, things like that. But please check it out. You can listen to it. You can watch it on the Korman's YouTube channel. All you do is look it up. You can see it. You can watch it there. You can listen to it. So I encourage you to do that. Okay. Follow us on social media. Let's get into the meat and potatoes here. What happens when someone dies? Okay. So we have to find a way to deal with whatever assets that person happened to own at the time that they died. So personal effects, things like their clothing and furniture, things like that are usually distributed by the family. You don't really need a will to deal with most of those type of things. But what we focus on when we're talking about estates is what type of assets are there that we can't just deal with without going through a formal process, because somebody has to have the authority to deal with those assets. So if you have a bank account, a GIC, an RSP, stocks, even a life insurance policy, if there's a beneficiary named in that, let's say a life insurance policy, for example, if you have a beneficiary named, my insurance policy is when I die, everything goes to my spouse, or the proceeds go to my children, or it goes to my friend, or whatever the beneficiary is named, then upon your death, the life insurance company will deal with that accordingly. They'll transfer that, whatever's in that life insurance policy to the beneficiary. You don't have to go through the will process. You don't need the probate process to do that, okay? So part of what everybody's trying to do with estate planning is to limit the amount that you do need the probate process for. Because when you have to go through that process, there's a whole procedure and there's costs involved. So anything you can avoid it using the probated will or dealing with assets without using that, that's what people try to do by estate planning. So that's sort of the game, okay? Now, we call it probate. Probate's not the actual proper legal term. For years, there were decades in the province, that was the terminology. We have to probate the will. A couple decades ago, they changed the act, and the proper term is letters of administration. So we still commonly use that interchangeably, probate and getting letters of administration. It really means the same thing. The proper terminology is getting letters of administration. We commonly refer to as probate, and I'm going to keep referring to as probate in this too. But basically what it is you have to get the court approval in order to use the will. If you need the will in order to deal with the assets, you have to first get the court approval. So it used to be applying for probate. Now you're applying to get letters of administration. Okay. Now, all that process of getting letters of administration is taking the original will with affidavits that are evidence as to who signed the will and who witnessed the will. You need two witnesses. So there's usually an affidavit that goes along with it, saying, I, David Korman, together with Sabiha Ali, witnessed David Gorski signing this will. That's basically what the affidavit says. But you need that sworn affidavit submitted to the court office with the original will. Can't be a photocopy of the will. It has to be the original will that has to be filed. It has to be original affidavit as evidence that it was signed properly and that there was two witnesses for it. So that has to be submitted. Now, when you submit that to the estate office, which is the court office, they charge a fee. And the fee is charged based on the value of the estate. And this sets out what the basic fees are. So it's basically $15 for every $1,000 of assets. So if it's $1 million estate, you'd be paying roughly $1,500 $15,000 in fees for that. Okay. So the whole idea is we'd like to minimize that tax. The way to minimize that tax is by not needing certain assets to be transferred pursuant to the will. So for example, if somebody had a joint bank account, husband and wife have a joint bank account, husband dies first, because we all know that husbands generally die before the wives die. I think there's a law or a rule to that effect. So husband dies, whatever's in the joint bank account automatically goes to the wife. We don't have to put the value of that bank account in the estate application to the court. So you don't have to pay a tax on the value of that. They held it jointly. Same principle applies if they had a joint investment account. Okay, first one dies, it's not part of the estate process. It automatically, title to that asset automatically goes to the survivor. Okay, if there was that life insurance policy that we're referring to before, let's say it's $1 million life insurance policy, and it named the wife as the beneficiary. So upon death, the life insurance company will pay that out to the beneficiary, to the wife. The value of that policy does not have to be part of the probate application. So you save the $15,000 on that. If the life insurance policy didn't name a beneficiary, if it was silent, then you would need the proceeds of the life insurance policy would form part of the estate. The value has to be included in the application, be paying the government a fee based on the value of that life insurance policy. Okay, so
David, if a property, say for instance, a parent passes away, and the will clearly stipulates the beneficiary of that property, even if it's split up, it doesn't need to go into probate?
Sorry, if the will
Yeah.
if the will names beneficiaries?
Yes.
No, the will is always going to name beneficiaries, but the will is really a catch-all. So if the whole idea, if you can deal with certain assets without needing the will, okay, so if there was joint bank accounts, you don't need to keep, you can deal with it. You don't need the will in order to deal with the bank account. If there's a life insurance policy, there's a beneficiary named, you don't need it to be part of the will, okay? If there was nobody named in the life insurance policy, then the insurance company will pay that $1 million to the estate. Okay, so now the estate's going to pay a fee to the government of $15,000 for that, and then the money will go to the bank account of the estate, and then it'll be distributed by the estate trustee in accordance with the will to whoever the beneficiaries are named in the will.
And if it's naming the children or the grandchildren that are actually the beneficiaries of that property, you still have to pay the tax, the probate?
Yes. If the authority to deal with that asset comes from the will, then you pay the probate fees. And then what happens is the whole application process, the probate process, or to get a certificate of appointment of a state trustee of the will, that's the correct name. Okay, that's what I've got on the screen here. You're actually applying for that. The whole purpose of the application is to get an estate trustee appointed, because we need somebody with legal authority to deal with the assets that are in the estate, whatever the assets happen to be, whether it's a bank account, investment account, RSPs, or real estate. Somebody has to have the authority. So you're really the estate trustee, who's the other terminology for estate trustee was commonly referred to as the executor or the executrix of the estate. It's
so
the same
how
thing.
do you go about it if you want to protect the property from paying that probate?
Right.
What is the
Right.
other measure that you can do prior to?
Right. So, and we're going to talk about that
Okay. All right, sure.
now in terms of real estate. So, but the application that you're making to the court is, if there is a will, you're applying to get a certificate as the estate trustee with a will. If there's no will, somebody still has to apply to become the estate trustee without a will. Okay. Now there could be more than one person that might be applying. If someone is named, if there is a will, then whoever died said, I want Sabiha to be my trustee. So Sabiha is going to apply to become the trustee. If nobody was named, if there is no will, Sabiha could choose to apply. I could choose to apply. We would have to go through a court process to decide who's the best person to be appointed. It's very expensive. So that's part of the argument why you're always better off to have a will than not have a will. Because either way, somebody has to get the legal authority to deal with the estate and be appointed as the estate trustee. Okay. Now I'm going to get to how this affects real estate. Okay. So real estate is just one of the assets that might be part of somebody's estate. So generally there's two ways that if there's more than one person holding real estate, there's generally two ways to do it. One is as joint tenants, one is as tenants in common. So when you take title to the property, when you're registering the deed, it'll be registered one way or the other. So if a husband and wife, just to keep it simple, own property as joint tenants, whenever there's the word joint, that means there's an automatic right of survivorship. So joint tenants is a real estate term. A joint bank account is the same principle. When the first dies, when the husband dies, nothing has to happen. Legally, the wife is entitled to the bank account, everything that's in the bank account. If they own real estate jointly, husband dies, nothing has to happen. The wife is the legal owner of that real estate. You don't need the will. You don't need anything. The wife owns it at law. Okay, you don't have to pay a fee based on that. The other way to hold title would be as tenants in common. And tenants in common, you can have a percentage ownership. So husband and wife could still own it together. It could be 50-50. It could be 90-10, 99-1. It can be more than two parties. They can each have a percentage interest. So let's just say the husband and wife owned it as tenants in common for some reason as 50% each. Husband dies. The wife still owns her 50%. Okay. But the husband's 50% now belongs to his estate. Okay, it doesn't automatically go to the wife. If he had a will and the will said, when I die, everything goes to my wife, then they have to go through the probate process in order to transfer his 50% interest to his wife. Now, when they do that, they're going to have to pay a tax on 50% of the value of that property to the court office in order to go through that process. Okay, because upon death, if it's not joint tenant, then everything goes to the estate. If there was a bank account in the husband's name alone, then the value of that bank account has to be included in the probate process. You pay a tax on it, even though the will says, when I die, everything goes to my wife. You have to pay a tax because you can't transfer that money to the wife until you get the certified will back from the court office that appoints the estate trustee. And then she would have the legal authority to transfer the assets of that bank account to the wife, to transfer the real estate to the wife or whoever the beneficiary was that was named. Okay, so that's a real important part of any type of planning that people should do. Or should they be taking title as joint tenants? Should be taking title as tenants in common? Okay, now what happens when we're going to sell real estate by an estate? So if title was held in that example as joint tenants, husband dies, and I said the wife is the legal owner, so there's nothing she has to do. However, if the wife is going to sell the property, okay, you're now acting as an agent. The wife wants to sell the property. Immediately before she transfers the ownership of that property to whoever the buyer is, a document has to be registered on title called a survivorship application. It's a real simple form. It's a fill in the blank form. I think we charge, I don't know, what do we charge? $350 or something to process it. But all it really says is husband and wife own title together. Husband died on September 1. Here's a copy of the death certificate. And they owned it as joint tenants. Therefore, the wife is the legal owner by right of survivorship. So we just have to register that. So there's no requirement that it get registered immediately upon death, but it does have to be registered before you transfer the title to the property. Or if the wife wanted to refinance the property, we would have to register that just to show that the title is in her name alone now and not the husband. But we're not paying a fee to the government or anything like that. It's a real simple process. Okay, now, if they didn't own it as joint tenants, okay, then you have to get a certificate of appointment of a state trustee. You have to go through the probate process, either with a will or without a will, okay? And any assets that you need the will for have to be included in that application process, and you have to pay the tax on it, okay? So joint bank account, you don't have to include it. If there was an account that was only in the husband's name, you have to include the value of that. If they had an investment account that was joint, you don't have to include it. If the husband had an investment account was in his name alone, you have to include the value of that investment account in the probate process. Insurance policy, if it named a beneficiary, you don't have to include it. If it didn't name a beneficiary, you have to include the value of that policy in the application. Okay, so that's where you're going really with when you're
So
selling.
joint tenancy is the only way that you don't have to pay the tax.
Yes. Only when there's that automatic survivorship. So
Right.
again, in that scenario, great question, Sabiha, husband and wife, husband dies, wife gets it, survivorship application will be registered at some point in time. No urgency to do it. It has to be done before she actually sells the property or refinances the property. Now, when the wife dies, okay, if she died, then there isn't a right of survivorship unless at some point in time she adds one of her children to title as joint tenants or something like that. But if she doesn't, when she dies, then that real estate's going to be included in a probate process upon her death. Okay, and I'm going to talk about it a little bit. So we're talking about properties held jointly or tenants in common. We'll talk about what happens when the second one dies or when anybody just owns a property on their own and there is no joint tenancy. Okay, I just want to just finish running through this process a little bit, because one of the important things that you have to know as an agent is, okay, let's say someone dies and I can't, can I close a transaction? Can I act for a seller of someone that just died? Okay, so the answer is, and this is a really important takeaway from this. Okay, someone dies. We're not using the example of a joint tenancy right now. Okay, the husband died, wife owned it as joint tenant. We're not dealing with the husband's estate to sell this real estate. They own it jointly, so the wife can sell it. So your client, your seller, if she wants to sell it, will just be the wife. You do not have to refer to the husband or the estate of the husband. She's the owner. You take instructions from her. She's going to be the vendor. We're going to register this survivorship application. So what happens when she dies, or anybody that's on title all by themselves? Okay, someone dies. The wife has now died. Her children come, or maybe they're named in the will, but they come and they say, okay, we want to sell her property. Can you list the property? Can you sell the property on behalf of someone that passed away? Well, the short answer is yes, you can. Now, you can, let's assume she had a will. She would have named someone in her will as her trustee, estate trustee. So let's say she named one of her adult children or all of her adult children as estate trustees. One of them comes to you and says, we want to sell mom's property. Here's a copy of the will. I'm the trustee of the estate. The will hasn't been probated yet. Okay. Now, that person has the authority to sign a listing agreement with you. You can actually enter into an agreement of purchase and sale, and that person has the authority to sign the agreement of purchase and sale on behalf of the estate. Now, your seller will be the estate of Joe Smith, or sorry, of Mary Smith. I'm using the wife. Let's say she was the last to die. Okay, it was Mary Smith. She dies. So the seller is the estate of Mary Smith. The person's going to sign the listing agreement. The person that's going to sign an agreement of purchase and sale is the person that's named in the will as the estate trustee. Okay, if there isn't a will, then you shouldn't be doing this. Somebody has to apply to the court to become the estate trustee. Okay, so you should not be doing a listing. You can't, if someone says, I'm going to apply to become the estate trustee, there is no will, you shouldn't be listing the property or signing agreement purchase and sale. But if they are named in a will, you can go ahead and do it. Now, I would get the lawyer involved, whoever's acting on the sale, I would get them involved in this process to make sure we got a properly signed will and they start the application. Now, here's the important thing you have to know. Yes, you can sign a listing agreement. Yes, they can sign an agreement purchase and sale, but the estate trustee cannot close the sale transaction until they get the certificate of appointment of a state trustee back from the court. Okay, there's no authority to transfer title to the property until the court approves the estate trustee as the person that has the authority. You have to complete the probate process. So the advice that you're always giving to your client, and the same thing coming when they come to me as the lawyer, is we got to start the probate process right away, as soon as possible. We have to get that application in. So any agreement that you're going to sign on behalf of an estate trustee, when that person's signing and it has not been probated yet, you have to have a clause in, such as this sample extension clause that we've got up here, that says the buyer and seller agree, the seller, upon giving 10 days, and it could be, you know, the 10 isn't, there's nothing magic to that. It could be 5 days notice, it could be 30 days notice, to the buyer, may unilaterally extend the date for completion 1 or more times, not to exceed 90 days in total, for the purpose of obtaining a certificate of appointment of state trustee. So there's no magic in the 10 days. There's no magic in the 90 days. It can be whatever days you negotiate and agree upon. The key is you're selling a property. You've got a closing date. Let's say the closing date is October 1st, but we don't know if we're going to get the certificate back from the court office in time. So you always want to have an ability to extend the closing date to give you as much time as possible until we get that certificate back from the court office. Because if we don't get it back by October 1st, we can't close. Your transaction is going to fall apart. So they're either going to agree to extend, or if you can get something of this type of clause in the agreement that gives the seller the unilateral right to extend for a period of time, that's better. Now, let's say you had 90 days and we get to the end of the 90 days and you still don't have it back. We still can't close the transaction. The deal can still be terminated by the buyer unless the parties agree at that time to further extend. Okay, so that's really important. And the problem is when we submit these applications to the court office, whether it's as a certificate of appointment, a state trustee with a will, without a will, there's nothing in the legislation that says once the government receives the application, they got to turn it around in 30 days or 60 days or 6 months or a year or anything. There's nothing. It's silent. It's whenever we get it back from the government, that's when it's going to be. And we can't, there's nothing we can do to change that. We will never get confirmation when we make inquiries and we're trying to chase it down, and we do it all the time. It's really hard to get through to anybody, number one. But if you get through to somebody, they're never going to tell you, oh, you know, we're getting close to reviewing yours and we will get it back to you within 10 days or within a month. They'll never give you any sort of commitment, verbally or in writing.
Can I call you back about a half an hour? I'm in the middle of a Zoom call that is about trustees and appointment and stuff. Very interesting. So I'll call you back as soon as I finish.
Okay, I think somebody should be muted. I'm not sure who that was.
David,
yeah.
My understanding is that if you do have an agreement of purchase and sale, as opposed to not having an agreement of purchase and sale on a property that's going through probate, that the courts will sometimes review them in a more timely manner and put them to the top of the pile.
Yes. Now, they will never confirm to you that they will do that. We've had that happen in practice. So what we've done sometimes is we've gone to sent something back to court to, hey, we submitted this September 1. Our closing date is October 1. We're now, a week away. We have a firm closing date. We have no right to extend the closing date beyond that. Please do what you can. They'll never respond and say, okay, we'll get it to you. Sometimes it magically appears just before closing. Okay, but sometimes it doesn't. But they'll never give you confirmation. So that's why it's always good to try and get these clauses in there. We've also had experience, we've been lucky or good, I don't know what it is, a couple times pre-COVID, where we were able to run someone down to the court office and try and get a hold of someone in person, say, hey, we got a deal closing in a couple days. We have no right to extend it. The deal's going to fall apart. Here it is. It's very basic, very simple. Can you get this in front of a judge? And a couple times we had success that way. Since COVID, there's been 0 people to talk to. You can't go find anybody. You can't go see a live body. Now, whether that changes in time, I don't know, but I would never count on it. So there's a strategy that has to be considered, because sometimes when we go to the court and say we have no further right to extend, let's say we had this clause in there, it gave us 90 days. Sometimes the court will say, oh, they don't really have to close October 1st. They've got another 90 days to extend. So we don't really have to process this for another, till the end of that 90 days. And maybe they'll get it back to us. So sometimes it's when we go to the court and say we're out of extension time, that's when sometimes we get it, but you can't count on it. So you have to know as an agent that you've got to make your seller client aware of that. We have a closing date. If we can't close on time because we don't have the certificate, the deal could fall apart. The buyer has a way to get out. Okay, if we can extend for a longer closing, that gives us a little bit of rope to deal with. And hopefully by the end of that extension period, we get it and we close. If we get to the end of that extension period, again, the buyer has the right to terminate unless we negotiate at that time with the buyer for a further extension until we get it. But we're basically at the mercy of the court. So we just have to be careful in what we're doing and think about what's the best strategy. Okay, so no problem selling a property on behalf of an estate. Now, when you're selling on behalf of an estate, if someone dies, the seller is the estate of Mary Smith, the person that died. Okay, let's say that husband and wife owned the property as tenants in common, or it doesn't have to be husband and wife. It could just be 2 people that own it as tenants in common. But let's just to keep it simple, let's say it was Joe and Mary Smith as tenants in common. So Joe dies, his 50% interest in that property goes to his estate. Mary wants to sell the property and retains you as the agent. I want to sell the property. So again, the property can be sold. The sellers are the estate of Joe Smith and Mary Smith. Now, Mary Smith can sign documents on her own behalf. If Mary Smith was appointed in the will as the trustee of Joe Smith, then she can sign the listing agreement with you. She can sign the agreement of purchase and sale on behalf of the estate because she's the person that's named as the estate trustee. But again, we can't close the transaction until Mary applies to the court to become the official estate trustee through the probate process. So, and then when she gets that certificate back, then she has the authority to sign all the closing documents on behalf of the estate of Joe Smith. And she'll also be signing it on her own personal behalf because she's a seller as well. Okay, but in that case, you have 2 sellers, Mary and the estate of Joe. Okay, now it might not be Mary that becomes the estate trustee. It might be one of their children, and might be somebody else that was named in the will. So you've got to see what the will says and see who was appointed as the estate trustee in the will in order to determine who's got signing authority for the listing agreement that you want signed and for an agreement of purchase and sale that you want signed.
So, David, would that also happen if they were tenants in common?
Yeah, that
Or
happens
is she
if they were
signing for
tenants in
herself?
common.
Oh, okay. All right. So
That
she's
happens.
signing for herself and then she's signing as his trustee.
Right.
Okay.
Or it could be Sabiha, Ellie, and David Korman have this investment property together as tenants in common, because we wouldn't likely own it as joint tenants. We would probably have it as tenants in common. So upon my death, my interest in that property goes to my estate. So Sabiha now wants to sell the property. She can only sell it with whoever is in control of my estate. Okay, so she's got to deal with my estate trustee, whoever that might be. So, and there would have to be somebody would have to be appointed to be my estate trustee. And they'd have to figure out, do they want to sell it? Do they not want to sell it? Does one want to buy out the other one? They can go through all that. But eventually, if the property is going to be sold, it can't be sold to anybody until you go through that estate trustee appointment process or that probate process. Okay. Does anybody have any questions or they want to raise?
So,
this part of
yeah,
it?
so Abu had asked something a little bit earlier, which is kind of a good question, I think. He says, what if husband and wife holds the title of a property through a holding corporation?
Okay, yeah. So if they own it through a holding corporation, then whoever controls that corporation or has signing authority for that corporation would be able to sign the documents. Okay, the corporation didn't die. The corporation exists. It's an asset of the corporation. So the issue is who has signing authority on behalf of the corporation. If there was only one person that had signing authority on behalf of the corporation and that person just passed away, then somebody is going to have to apply to become the signing authority on behalf of that corporation. So one of the things that we do when we discuss preparing wills with anybody, and it's part of it's part of the back half of this presentation, which we may or may not get to, is that's one of the questions we ask when we're doing wills for anybody. Do you own a holding corporation? Do you or a PREC? Do you own any private shares in any private corporation? Because there is a procedure in Ontario where you can actually create two wills, or we call them dual wills, because you can create a will that will deal with assets of a private holding corporation exactly for that purpose. So you don't have to go through the probate process in order to deal with a corporation. So if I have a holding corporation, for example, and I do a will, let's say I'm naming, if I die, everything goes to my wife. So that's my basic will. So I would still do that basic will that'll deal with every asset that it might have that we don't own jointly. But I can do a secondary will that's just for privately held shares that I might own in a private corporation. And again, I can point, my wife could be my state trustee under that will. And I say, when I die, I want any shares that I own in a private corporation to go to my will, to my wife. So that would give her the authority upon my death. She would become the shareholder. She can appoint herself as the officer and director and signing authority for that holding corporation. And she can deal with that corporation. It doesn't have to go through the will probate process. So your seller of that property, it's still the corporation. The corporation is a legal entity. The corporation is still selling it, signing a listing agreement, signing an agreement of purchase and sale, signing the closing documents. Somebody is the signing authority of that corporation. So if I had a secondary will that appointed my wife and all the shares to her, then she would become the signing authority and she would be the person signing everything on behalf of that corporation. You don't have to go through, let's talk about what if you didn't have that secondary will. The shares that I own in that holding corporation would go to my estate. Okay. And then because of that, and my will might say everything goes to my wife. So my wife would ultimately become the shareholder of my holding corporation. But because I didn't have the secondary will, I have to include the value that's in that holding corporation, whether it's real estate, holdings, or any other assets that corporation owns. The value of that corporation has to be included in the probate process. And you pay a tax to the government based on the value of that. So that's why it's such an important question whenever we're doing wills for anybody is, do you own shares in a private corporation? Because if so, then we're going to do two wills for you. A primary will that deals with all of your assets that you might happen to own at the time that you die, other than your private shares in private corporations, and a secondary will that's going to deal with the private shares that you own in your private corporation. Okay, and this is a legal method the government authorized. It's a great way of estate planning and planning, especially for anybody that has a holding corporation, including shares in a PREC. Okay, so that's the way you get around that. So that's a great question. So there is some information on the back end of this slide presentation that deals with just that, with dual corporations. So you'll have this for reference purposes as well. So Sabiha, I know I want to be sensitive to time. We've got about 15 minutes left. So there's two options. If there's people have questions on what we've talked about so far, we can deal with that, Or if you want, I can go on and talk about what goes into a basic will and some of the basic issues for signing.
So David,
wills.
I think this is quite an extensive topic, and I really don't want to squeeze it in one. Maybe we can do another second session. I mean, I think this is a lot of information, and a lot of people will have some questions. So I think maybe we should, somebody's,
Yeah, I think that's
guys, if
a
you
great
can keep
idea.
it mute for a quick second, and then I'll open it to an open forum. So I think we should just, I think, pause right now, and then I can send out another invite for a secondary, maybe in a week or so,
Yeah,
follow up of this, yeah?
yeah,
And
I
we
think
can
that's a
discuss
great
all of that.
idea because
Okay. It's
yeah,
just a really big, heavy topic, and I think, we should just kind of cater to these questions. I think, Yajnish, you wanted to ask something?
Just a second. Yeah, I have question, David. My concern is I'm 60 now, right? And I've been a cancer patient. In 2014, I went through cancer, prostate cancer. I own 3 properties right now. And my concern is what time I should add my kids to the title.
well, that's a great question. First of all, I hope you're doing well and you recover fully.
Yes.
But that's a great question. Okay, and we get asked that question a lot. And even going back to the example of Mary and Joe Smith. So Joe dies, Mary owns the property. Now, when she dies, she'd rather not pay probate fees or have her estate pay probate fees on her real estate or any other assets. So that question comes up. Should I add my children to the title of my property? And the answer is sometimes. Okay, and that's not intended to be evasive. I'd rather give you a black or white answer as opposed to a gray answer, but the answer is not always the same. We have to consider it at the time. Because let's say, because as soon as you do that, let's use you as the example. You're 60 years old. Okay, so you have kids that are how old? Like in their 30s? Let's say, okay. So let's say you add your adult children to the title, to your property. Now, if you decide you want to sell that property because you want to buy another property, or you want to move to Florida, or you want to travel the world and just cash out, or you want to refinance that property, your mortgage is due, you got to refinance, or you want to take more out, or whatever, you can't do any of that without going to your kids and getting their consent and getting them to sign on. So the issue really becomes control. Do you want to lose control of your assets? Now, most of us think, we've got great relationships with our children. They would never do anything to cross me. But we run into it so many times where relationships break down, or somebody just doesn't think your idea is good. Why are you going to sell your property and you want to travel on a cruise line for the next year? But that might be what you want to do. Or you want to, sell and move to Florida, and your kids might object to it. So at some point, depending on your relationship with who you would name as joint tenants, your children, you're losing control of your property. So a lot of times if you're 60 years old, not a good idea to do that, because we never know when we're going to pass away, but we all expect we're going to live to 100. So now if you're 80 years old and you need the assistance of your children to manage your affairs, and you're a little closer to the end, or you have a terminal disease or something, at a certain point, it is appropriate. When we get asked that question from someone who's 80 years old, our inclination is to advise them differently than if they're 50 or 60. Because 50 or 60, you generally don't want to lose control of that. And if you have to, and all of a sudden, if you do die suddenly or something happens to you and they have to pay a probate fee, like, so be it. Okay, that is a better choice than losing control of your own life. Now, when you get to a certain point in life where that changes. Okay, when this is going to be the last home you're ever going to, you're not going to be living anywhere else. You're not going to be looking to move it, to cash out, to go to Florida. Then at some point, it is appropriate to add your children as joint tenants in order to try and save the cost of the fees for the probate. So How's that for an answer that goes both ways?
David,
John,
sorry, David, can you mitigate those risks of possibly not being aligned with your children by getting a power of attorney signed?
Well, great question. Power of attorneys and wills are two different things. Power of attorneys apply while you're alive. You give someone the authority, two different forms. Generally, one is a power of attorney for property, which is signing authority on your behalf, or a power of attorney for your personal care, which is authority to give, you give someone to instruct a doctor for your personal care. So the one that David is really referring to is the one for property, which is signing authority on your behalf. Now, those type of documents are really powerful. Now, that can be limited to someone can only exercise that power of attorney if I'm incapacitated, okay, if I'm unable to make decisions for myself. You can give someone the authority to deal with that. Or you can give someone a general power of attorney they can use at any point in time. That is an extremely powerful document. So you give one of your kids a power of attorney that they can use at any point in time. They have the legal authority to sell your real estate, to sell your property. Okay.
I was more referring, David, to ask the kids to give you power of attorney over that 1% interest they have in your home, right? So if you, let's say, wanted to go ahead and sell the house and go on a 12-month cruise somewhere, you don't necessarily have to ask your kids permission because you have a power of attorney over, limited power of attorney over that 1% interest that they have in your property.
Yes, you can do something like that. That's a great point. And you can also couple it when you do transfer title to your children as joint tenants. A document can be signed at that time. The reason we're doing it is for estate planning purposes and basically just to avoid probate fees. But my children that I've now added to my title are acknowledging that the real intent is that I still have control of my property, and they'll sign whatever documents that I require if and when I want to sell it or refinance it, that they'll do whatever I want, that they'll take instruction direction from me. Okay. So really those children, they're added as joint tenants, but they're really holding that interest in trust for you while you're alive. And then upon your death, it'll become part of your estate. But the good news is you don't need to go through the probate process because you've already added them as joint tenants. So it'll just become their property.
Yeah, beautiful. I guess the only issue really becomes is that the power of attorney can be revoked by the kids at any point in time.
Right.
So it gets a little complicated, but if you have them sign that agreement that you just referenced in conjunction with a power of attorney, then you're pretty well protected.
Yes, because they've agreed up front that they're going to cooperate and sign whatever documents on the instructions of you, because you're really the owner of the property. You're just doing this for estate planning purposes.
Awesome. Thanks, Dave.
Yeah, there's another question from Gabby. She asks, with respect to investments, if you name a successor holder instead of beneficiary, will there be tax benefits?
Sorry, read that again, because I'm not sure.
So in an investment, if you name a successor holder instead of a beneficiary, would there be tax benefits?
Yeah, I'm not sure what that terminology successor holder.
The successor holder?
Yeah, usually when there's an investment account, it is a successor holder probably is the beneficiary. It might just be terminology that's being used by the investment company, but it probably referring to the same thing. So if you name a beneficiary that, upon my death, this goes to my successor is my wife or it's my children. That's, I guess, what they're referring to successor holder. That in fact is the beneficiary. Okay, that it's like they're the alternate or the successor. So I guess that's just the terminology that they're using, but it means the same thing. You've named who it's supposed to go to if you die. So if you've named someone in the investment account, the investment company will just transfer the assets of that account to whoever you've named as the successor or the beneficiary. I think we're referring to the same terminology, just different way of describing it.
David, I have another question. So I had this with my own property, and I don't know what you feel about this, where my property was in my father's name, but there was a trust agreement that I was the sole beneficiary of that property. So when my dad passed away, it was a very simple transition, and there was, nothing applied, no taxes applied at all. Is that something that people can think of doing as well?
What was the document?
It was a trust agreement.
Oh, it was a trust agreement. Okay.
Yes.
So yeah, because there was a trust agreement. So what your dad was really saying, I'm not the real owner of this property. I'm just the legal owner on title, but I'm holding the property in trust for Sabiha, who's the real beneficial owner. It's really her property. So then you're just doing a transfer from the trustee to the beneficial owner on the basis that it was really always Sabiha's property. So
Right.
if the trust documents support that, then we just register it to Sabiha because she's always been the beneficial owner of the property in any event. There's no land transfer tax payable. The property's always been hers. It was just
for a very
just holding the title
right.
on your behalf.
So for an elderly parent, would that be something advisable to do instead of getting into a will and all of that?
Well, it's part of the process. But again, if that's all you had, then like in that scenario, Sabiha, you're the real owner of that property. So if your dad at some point said, hey, I want to sell this property or I want to refinance this property, he can't do that without coming to you because you're the real owner of the property. So you can't do it both ways. So the best thing is, get proper legal advice at the time to understand the whole fact scenario and what the real intentions of the parties are and what the capabilities and capacity and what point in life they're all at, what the relationship is in order to figure out the best way to structure that.
Right. If anybody has any questions, please go ahead, unmute yourself.
I have a question. It's Regina. So I have a situation. I don't know if David, can you hear me?
Yep.
Yes. Okay. So with my own situation, even where I'm trying to figure out right now how to do it, I'm the only one on the title, but it's my husband's matrimonial home as well. God forbid I pass away, there is no will. I know, first, Regina, why don't you have a will? I get that. But let's say, so for example, there is a will. Is he going to be, obviously, is he going to be the beneficiary? It's obvious. Or no, it's not obvious.
There's no such thing as obvious. A will is a very personal document, and it's up to the person to decide what they want to happen upon their death. So there's nothing necessarily obvious, but I'll tell you what happens if you don't have the will. Regina, if you die, you pass away today, title's in your name, the title then belongs to your estate. Okay. Somebody has to apply to become the estate trustee without a will. So let's say your husband applies. So that would just, let's say and nobody is applying against him. Okay, because maybe sometimes there's competing people that want to apply, but let's say your husband applies and he gets the appointment. So that appoints him as the estate trustee. That means he has authority to deal with the estate. Now, the second question is, who is the beneficiary of the estate? Okay, now different people can make a claim on the assets of your estate. Your husband, because if he is your husband at the time of your death, he has a preferential claim ahead of other people under the Succession Law Reform Act, but it's limited. And I think it's the first $200,000 of value. Don't quote me on that because I never remember for sure, but it's something like that. It's not unlimited. He has a claim for the first couple $100,000, but there's other people that can apply as beneficiaries. And that could include children, nieces, nephews, cousins, anybody else that they think, might be able to make a claim. So, but it's not automatically your husband's. Okay. So he's wearing two different hats. One is his role as the estate trustee, but in that role, he's got to circulate to let other people know that you've passed away. Anybody that might have an interest in the estate has to apply and state their case. And if he can't sort it out, then he's got to go to court to get a court order to decide who actually shares in the estate. So that's why I'm always telling people it's way better to have a will than not have a will. It's such an expensive process. People are trying to save a little bit of money and not paying probate fees. It's so much more expensive to not have a will and to have to apply to the court to have someone appointed as the estate trustee, and then to apply again to the court to determine who the beneficiaries of the estate are. It's a very expensive and time-consuming process.
Okay.
So it's always better to have a will. The other thing I'll tell you
Yeah.
is, let's say you don't pass away, but you want to sell this property. You can't sell the property when it's in your name alone without your husband consenting to it.
Oh, I understand that.
Right. And
That
you can't refinance without consenting to it. And that's got nothing to do with the estate or the wills. That's Family Law Act protection for him. Okay. As the non-titled spouse, just so a spouse can't sell a property or refinance a property without their spouse under the Family Law Act knowing about it. So they would have to consent to it. So that's just the other point.
And a written will, people used to have a written will, I guess, like back in the days, because I've seen a few of them, and I was trying to figure out at that point to ask you, is the written will the same as the, is it like the same in the courts of, when you're presenting? Is it the same one, or it has to be approved by someone?
Well, yes, that's a good question. That's why we're going to do a second webinar on wills, because wills, there's two things that are really important with wills when you do have a written will. One is that the content is correct and it's drafted properly. And in order to name the appropriate trustee, in order to name the beneficiaries, et cetera, and go through some of the other issues that you have to deal with when a will. So we'll discuss that in a future webinar. But the second thing is you have to make sure that a will is signed properly. It has to be signed properly by whoever's making the will, and it has to be witnessed properly by people that are qualified to witness the wills. And that's why I'm always encouraging you, don't do an online will kit or power of attorney kit. They get you in so much trouble, and the money you think you're saving is going to cost you thousands and thousands of dollars to undo that damage. It's not an expensive process to get a will done, to get power of attorneys done. It's a way better idea to do that. And we can talk more about that when we do a seminar or a webinar on wills and power of attorneys.
David, I have one more quick question, please. Yeah, David?
Yeah, go ahead.
A few years back, there was a family, they were my relatives. I sold their home in the Pickering and brought them a house in Mississauga. The husband died after 6 months, right? So the wife, I know she has to go to the lawyer and change something, the title to her name, because both were a joint tenant in the matrimonial home, right? Is anything document we have to do after somebody died in the matrimonial home?
Sorry, they owned the title as joint tenants?
Yes.
And then one of them passed away?
One passed away, yeah.
Okay, so that's what I was mentioning earlier. If they owned it as joint tenants, they don't have to do anything until they actually are selling the property. So immediately prior to the sale of the property, we have to register that survivorship application, which is a real simple thing to do. It's not complicated. We just need a copy of the death certificate. We complete a form. We just have to register that, which is just putting on title that one party died, the other party is the owner because they held title as joint tenants. So that's the rightful owner by right of survivorship. We just have to put that on title before that person can then transfer the title to somebody else.
No, I think you misread. They already sold the house. The husband was alive that time. Then they moved to the new house in Mississauga together. After 6 months, he died.
Yeah.
The wife she approached me one time, I have to do some paperwork, the lawyer who did the closing. Yeah. So, because is any legality required after when your partner died?
Yeah, well, again, you don't have to do it. There's nothing saying you have to register a survivorship application as soon as someone dies. Okay. But she will have to do it eventually.
Okay.
prior to selling the property or prior to refinancing, she'll have to do it.
I got you.
She could do it now. She could do it at any time.
Yeah, yes, she did.
Eventually,
She did.
it's going to have to be done.
Yes, she done. Because I think maybe somebody told her you need to get that done. Thank you.
We have just one more question. It's what kind of complexity might be involved while adding someone to the title if the property still has a mortgage on it?
Yeah, well, that's a great question too, because we were talking about, can I add my children to the title? Should I add them on as joint tenants? If there's a mortgage on title, okay, most mortgages prohibit you from transferring the title to anybody else without getting the lender's prior written consent. So if you want to add your adult children to the title, but there's a mortgage, you have to go to your lender first and say, I want to add my adult children. And they have to consent in writing before you can do that. Otherwise, you're in default of your mortgage. Okay. Now, that raises another issue, because let's say the bank says, yes, we consent, which most of the time the bank will. Because as soon as you add them to the title, they become responsible for the mortgage, as if they're guarantors of the mortgage. They're now owners of the property. They become responsible for the mortgage. So that creates a whole other issue. That might affect your children's creditability because they now own this property. They have an interest in this property. They're responsible for the 100% of the mortgage. Okay. Even if they own a 1% interest, they're responsible for 100% of the mortgage if the mortgage goes into default. So that's another factor that you have to consider as well. Number one, you need the consent of a lender before you can transfer the title. And then do you really want to do that? Because now you're making your children responsible for your mortgage. And that might prevent them from getting a mortgage on their own property. It might affect their credit rating. So those factors have to be considered as well. So great question.
And David, just a follow-up question on that, like say like the adult children doesn't have their first home yet bought and you ended up adding them in the title. So do they lose now the first time home buyers land transfer tax things also?
Yeah, another great question. And the answer is yes, they do. Because when you do buy a property and you want to get that land transfer tax rebate as a first-time homeowner, the affidavit that you're asked to swear at the time is, have you ever owned a home or an interest in a home anywhere in the world? So if they've been added to a parent's title, whether it's a property in Ontario or it's a property in another country, they have an interest in a home. And because they have an interest, no, it doesn't matter what the percentage is. It could be a 1% interest. But if they had an interest in a home anywhere in the world, they now are not entitled to that first-time home buyer's land transfer tax. Even if they've never had the benefit of that, they're not entitled to it. Great question.
Thank you, David.
Okay, thank you everyone. It was a great session, David, as usual. And I think we'll do a follow-up for sure. Sooner than later so that it's all fresh in everybody's mind, but amazing content. Thank you so much, everyone.
Thank you, David. Thank you, David.
Everybody for attending, and nice to see some smiling familiar faces, and eventually we'll get back to doing this live.